Bill Henshaw here again, and during the videos we've been doing today, I just did a case update on Oregon v. Mitchell that you'll find very interesting. And along the same line, that case talked a lot about the events during the Reconstruction period in the mid 19th century. And I have a really excellent textbook on this subject called The Critical Year by Howard K. Beale. It was done in 1930, and that's about my cutoff date for taking any serious American history books. Because after that, FDR gets in and the New Deal, which he didn't bother to tell us was nothing but a deck of 52 jokers. Everything else has been so, I mean, my goodness, you can't trust anything basically printed after that time, not without serious look at it. Anyway, Beale did a lot of research on his books, just like Anthony C. Sutton did on the books that he wrote, Wall Street and the Rise of Hitler and books like that. Well, Beale did the same thing. And he gets a lot of confidence in me because he did what he did. And he talks about this. It was the election year of 1866, and the nation still had a chance at that time to elect a Congress that would essentially have prevented the enactment of the first Civil Rights Act, the Freedmen's Bureau, the ratification, quote unquote, of the 14th War Amendment. If we had gotten people in there, especially Democrats, not radical Republicans, and if the South had been represented, by the way, in either or both houses of Congress, the difference, actually, the election wouldn't have been as important because the radical Republicans could not have gotten the necessary 2/3 to override the vetoes of Andrew Johnson. Damn. But even with that, the problem was with that election, that was going to decide, the course of Reconstruction, and unfortunately it did. So Beale, who did a lot of research, I'm going to read you a couple of things I'll be incorporating into my jury instructions, those of you that have those, and there's 572 of them right now in that packet. By the time I get through before the end of the spring, there's going to be close to 600. These will be added to it that make our case even more. And this is not according to defense counsel in Oakland, my interpretation of the law. Sick and tired of hearing that crap. So the first quote says there that part of the opposition to the radical measures came from men who objected on the ground of constitutionality of congressional action. The position asserted by Congress, wrote a friend of William Tecumseh Sherman, a virtual abrogation of the government we had before the war, and an attempt by mere politicians to make a new government through usurpation of the manifest purposes of sheer partisan supremacy without an appeal to the legitimate way made to the people of the several states as the original source of power. In his own state, Lyman Trumbull encountered opposition to the Freedmen's Bureau and Civil Rights Bill. Do you really believe, wrote one of his constituents, that Congress has under the Constitution authority to create a power and exercise it by national agents in the states? Noting here that the Freedmen's Bureau and the Civil Rights Bureau were protected by federal military. That ought to tip you off as to what the jurisdictions of the courts are. So it goes on. The next jury instruction, but most of the opponents of radicalism objected to centralization itself and opposed it only less vigorously if it were to be brought about by a constitutional amendment than if by illegal legislation. Orville H. Browning, a key advisor to President Andrew Johnson, wrote, "One of the greatest perils which threatens us now is the tendency to centralization, the absorption of the rights of the states, and concentration of all powers in the general government. When that shall be accomplished, if ever, the days of the Republic are numbered." And you can argue they may have been for the last 150 years. That's prescient. Next jury instruction. In his widely read letter to the Cleveland Convention, pro-abolitionist Henry Ward Beecher declared the federal government is unfit to exercise minor police and local government and will inevitably blunder and fail when it attempts it. To oblige the central authority to govern half the territory of the Union by federal civil officers and the Army, exactly the formula in at least the Civil Rights Act of 1866 and Reconstruction Act of 1867, my note, is a policy not only uncongenial, to put it politely, to our ideas and principles, but preeminently dangerous to the spirit of our government. However humane the end sought and the motive is, it is, in fact, the course of instructions preparing our government to be despotic and familiarizing the people to a stretch of authority which can never be other than dangerous to liberty. That's exactly what's going on. As I said earlier from T.S. Eliot, the quote that the last temptation is the final treason, to do the right thing for the wrong reason. You simply can't open that door. Next jury instruction. Back of Andrew Johnson's opposition to the bills and to the 14th War Amendment, my note, was the realization that once congressional omnipotence was established, nothing in the federal government nor in the sanctity of the states could restrain the radical Congress. To the men who sensed the danger of ultra-centralism, Johnson seemed to be the defender of the American system of government. Exactly the reason he was impeached. David Dudley Field, brother of Justice Stephen J. Field, on the Supreme Court for, at the time, a record 34 years, and oh, by the way, author of the Dudley Codes. He was the first one to draft codes for use in the states. Said that it is of more value to the people of the country than the rise or fall of any party or success or failure of any measure. In the present unhappy difference between Congress and the President, the latter, in his sense of obedience to his sense of constitutional duty, declines to the vast patronage and power, civil and military, which the former would give him. We honor him for this. We believe the whole country will do as much. It knows no one man has suffered more or struggled harder for his convictions. And yet the 39th Congress impeaches him. Next jury instruction. Gideon Welles, a Lincoln cabinet appointee, pointed out that Lincoln's and Johnson's constitutional views were identical. The real and true cause, said Welles, of the assault and persecution of Johnson was the fearless and unswerving fidelity of the President to the Constitution, his opposition to central congressional usurpation, and his maintenance of the rights of the states and of the executive department against legislative aggression. Wouldn't we love to have somebody like that in office today? Wells described the Reconstruction struggle as a conflict carried on by a fragment of Congress that arrogated to itself the authority to exclude states and people from their constitutional right of representation against an executive striving under infinite embarrassment to preserve states' federal and popular rights. In the end, Johnson's opposition prevented, whether for good or evil, a fundamental change in the form of our government. This he did accomplish, though he ruined himself in the process and lost in the more immediate Reconstruction quarrel. Damn, so these are the kind of quotes you get out of this book. If you can get a hard copy, or even a soft copy, maybe on Albert's, I don't know what it sells for these days. I got mine back in about 12 or 14 years ago. I got it for, I think, $6 on Albert's. It's worth a hell of a lot more than that It could be available digitally on some digital format websites that have things like this. You can look it up. It's, of course, well out of copyright now, 90 years later. I prefer to have it in hard copy. I'm the old school. I love to have something I can hold in my hands, but that's just me. But a book like this is invaluable. It's a great resource to understand what went on there and what the real agendas were. And again, I never heard of Howard Burke, and I never heard of the critical era at any time in my 12 years in school. Damn, and I'm sure you haven't either. And it maybe should have been front and center, especially in 10th, 11th, and 12th grades, civics and U.S. history. Not there. But this is the kind of thing, the material you get, it's what I offer in my materials. All these are going to go in my jury instructions, and they'll be incorporated into a lot of my briefs that some of you already have who've gotten my documents, that makes them even better and harder to refute. I mean, this is hardly my interpretation of the law here. It's someone in authority speaking about it, not me. So that said, remember to send me an email at uwin@gmail.com, and I'll give you some information on my materials, how to get a hold of them. And also remember to subscribe, like my videos, and tell your friends. Thank you.